it's 16:31, exactly 1 minute after we were scheduled to start our meeting. Greetings from Tbilisi. I think we shall start, and the meeting is recorded, and whoever cannot join us right now, they will have opportunity to listen to the discussion later on. Greetings to everyone. I see our members from different countries and different cities, and it's very nice to see you all here and to have you all here. I think we will have very fruitful discussion on this very important and relevant topic, especially, at least in Georgia, it's right now very relevant, but in other countries as well, as much as I know. Very briefly, I will remind you that this and every other discussion we've had in this format has been supported by the USAID Rule of Law program, and I thank them very much for this very important work they do. The discussions are organized and provided to you by the Democracy Index Georgia, with cooperation with the group of independent lawyers. This is also Georgian group of legal experts. We have this amazing group of experts from so many different countries, 30 countries, 60 people now, the network of judiciary reformers. I will tell you that we're gonna have, again, with the support of the USAID Rule of Law program, we're gonna have an opportunity to continue our very important discussions during next year. So I encourage everyone to continue their participation, to become more active. This network is an amazing opportunity also for many other reasons, because we have we can engage into different discussions or ask questions and information through our group emails beyond our discussions, and or share important information about conferences or other online meetings and discussions that you members of this network are conducting in different countries, which might be interesting for the members. So please, please use this platform for so many different amazing professional purposes. Our today's topic is the role of judges, chief justices, and court presidents, as we call it here in Georgia, in the judiciary system, for the independence of the judiciary, internal and external. I said that it's very relevant for Georgia, this topic right now, because we are undergoing the extensive reform in the framework of the European integration, and court presidents have always been the powerful figures in the judiciary system, in different times differently, but they have influenced as internal independence of the court system, as well as they have even today very important influences in the High Council of Justice. The role of court presidents is really something that we should discuss. We have amazing speakers today. David Kosar, who has done extensive work regarding to study the role of court presidents and chief justices, head of the Constitutional Law Department at Masaryk University, Czech Republic. We have an amazing speaker, representative from the OSCE Office, Caroline Hammer, who is rule of law advisor for the OSCE Office. And she will be talking about very recent recommendations the OSCE updated after the key recommendations of 2010. Now we have 2023 Warsaw recommendations, and role of court presidents is there as well, of course. And the last but not least, we have Nazi Janizashvili, head of the local non-governmental organization, Georgian Court Watch, who was previously a member of the High Council of Justice and had encountered and approached the issue of court presidents from different angles. And in Georgia, court presidents are appointed by the High Council of Justice, so she took part in that as well. So I don't know if she already is here, but I know that she will be joining. And with this amazing pool of speakers, we start our discussion, and I encourage everyone to then participate in the questions and answers and opinions session we will have afterwards. Thank you, and I give the floor to David. Please, David, the floor is yours.
Thank you very much, Eka. First, I would like to double check whether you can hear me well.
Yes, I can hear you very well, and hopefully everyone else too.
Wonderful. And second double check, can you see the presentation?
Yes.
Wonderful, cool. So first of all, thank you very much for having me. It's my pleasure and honor to see so many familiar faces, and I'm looking forward to your comments and suggestions and criticism of what I plan to say. First of all, I would like to make clear that the scope of my presentation is somewhat more narrow. What I will say, of course, to a great extent applies to court presidents and chairpersons at all levels, all tiers of the judiciary. But in my talk, I would like to focus primarily on the presidents of apex courts. That's the traditional understanding of a Chief Justice of the Supreme Court of the United States. And in other countries, there might be more chiefs. There are, 5, Supreme Courts in Germany. In other countries, there are separate constitutional courts. But I'm looking primarily at the apex courts because I think they are different, and Chief Justices have a specific role and specific powers. So here is a brief outline of my presentation. I will look at who Chief Justices are, then discuss the formal, informal powers and roles, and I will also like to engage in other topics such as interaction between Chief Justices and other actors, and selection and dismissal of Chief Justices. So who are Chief Justices? They are important figures. They engage in judging and judicial governance, and we often learn about how important they are only once attacked. For instance, in Pakistan, Chief Justice Chowdhury was suspended. In Venezuela, Vice Chief Justice Rieke was removed. You all know, the case of Chief Justice Baka in Hungary, or Chief Justice Małgorzata Gersdorf in Poland. But interestingly, there were very salient appointments of Chief Justices in Australia, Norway, and the United States, but also removals outside Central and Eastern Europe, Tim Carmody in Australia, Carlos Divar in Spain, and so forth. So we can see that, if political leaders wish to exert a pressure on the court, they often attack Chief Justices. And you can see that this attack might be even physical, let's say, in Senegal, in Uganda. Situating my talk in a recent research, a lot has been said of Central and Eastern Europe, as I said, Gersdorf, Baka, and so forth. But there is also research in a book called Towering Judges that focus on Chief Justices qua individuals. There is also a recent collection called Constitutional Heroines, edited by Erin Delaney and Ross Dixon, that focuses on female Chief Justices. And there is also more recent research that focuses, and that's what I would like to talk a bit more on, Chief Justices from the institutional point of view. So as I say, I look at the chiefs. Quite often, we talk about, chiefs of the Supreme Court. Esther Hayut, who just recently finished at the Israeli Supreme Court, is a prime example, but also constitutional courts, supreme administrative courts, and special tribunals. So Why are Chief Justices so important? I already mentioned that. I mean, they are very powerful and influential actors with wide powers. I very, let's say, tentatively divide these powers into two categories. First of all, Chief Justices have tremendous role in judicial decision making. So they can even influence the outcome of the case. Sometimes they have a tie-breaking vote on the Supreme Court. Sometimes they can easily, build coalitions and frame the debate, including, the order of the arguments, the hearing, and so forth. And the second group of powers concerns judicial governance, which I think can be divided into 5 subgroups. First of all, it's a managerial role, so it's crucial power, to allocate cases, to do the case assignment, to choose the judge rapporteur, sometimes even assign law clerks and all sorts of other things in the court. Then there is a chairing role by chairing the session of the court. Again, the Chief Justice exercises a significant powers. Thirdly, there is a public role. Chief Justices usually have very easy access to the media, and journalists are hungry, for their comments. So they are very, important public figures. Sometimes they can even engage in judicial diplomacy, both at home and sometimes even abroad. Then there is I would say, a structural intent-based role, which means that Chief Justices are communicating quite often with representatives of the other branches, including the President, the Prime Minister, and so forth. And finally, in many countries, especially in, let's say, in this region and Central and Eastern Europe, Chief Justices have also important influence, either direct over selection or promotion of judges, sometimes indirect, for instance, via the Judicial Council. So basically, they are having dual roles. They have a role vis-a-vis external actors, as well as vis-a-vis judges of their own courts, which raises all sorts of questions regarding internal judicial independence. So it's important to acknowledge that they are having the powers within the court and within the judiciary, but also powers outside the court. And I think these powers, concerning, extrajudicial activities are far broader regarding Chief Justices than other court presidents. So when we look at the formal powers of Chief Justices from let's say, more nuanced perspective, there are at least 8 dimensions. They can play a significant role. I mentioned, the administrative role and the personal role, which is, the influence over selections, promotions, and even disciplinary activities. They also play an administrative role, which is, as I said, setting the work schedule, case allocation, and so forth. But importantly, they also sit on the budgets in many countries. They have to negotiate with ministries. They might have influence over the education of judges. They often also decide on how much information is shared with the public. Increasingly important arena is also, digital governance. Basically, how you manage, the case files internally, who has access to what, and so forth. In some countries, they also take the lead in preparing the codes of conduct. You might have seen a recent code of conduct for judges of the Supreme Court of the United States that responded to some of the earlier criticism. And also, that's very specific, I would say, regarding constitutional tribunals. Chief Justices sometimes have also important regulatory role. Therefore, they can comment on new legislation related, to the judiciary, but may also kind of change the procedural rules of a court. So you can see that these powers are extremely broad. And of course, it's not all of it. I mean, chief justices also have enormous informal powers and play several informal roles. We tried to look with my colleague Adam Plissa earlier on, 5 years ago, on a couple of jurisdictions in Europe to see in what area court presidents, especially chief justices, are most powerful. And you could see that in Central and Eastern Europe, when court justices are really, chief justices and court presidents are really powerful figures, especially regarding, the judicial careers, administrative powers, also jurisprudential powers. It's also interesting that, for instance, Nordic countries, they might, look slightly, differently, where the focus of chief justices is quite often on the, let's say, financial, media, and administrative dimensions. And at some supranational courts, it's again slightly different, even though you can see that, for instance, Koen Leenaert, the president of Court of Justice of the European Union, is a very powerful figure across the dimensions. So when we start thinking about that, it's important to understand that, powers do not necessarily translate into influence, and sometimes also vice versa, because there are other contingent circumstances that matter. So it's not only about formal powers, but also informal powers and other factors. I mentioned a couple of those. I would like to hear your comments on that. For instance, the length of the term of a chief justice and its renewability may change, the dynamics, because the longer the term, the stronger the chief justice. If you look at jurisdictions such as Brazil, where the term of a chief justice is very short, it's just 2 years, then of course the chief justice cannot do that much. But if you have a chief justice who has an unlimited term or is appointed for 10 years, then of course, I mean, his legacy can be much bigger, and he can exercise the powers differently. Of course, if the term can be renewed, then the chief justice might try to please the organ or the person that is renewing his or her term. So again, might change the dynamics. I think that the information asymmetry also is an important factor, because quite often, the chief justices have better information of what's going on within the judiciary. The institutional design of the judiciary is another factor. So there are some, let's say, pyramidal judiciaries or hyper-pyramidal judiciaries, like Brazil, where you have a super powerful Supreme Court at the top, or perhaps Mexico is pretty powerful as well. Until very recently, it was, for instance, the Slovak Supreme Court. But there are other jurisdictions where there are several apex courts sitting next to each other. So there is a sort of competition between them. There are other jurisdictions that have constitutional tribunals that sit outside the ordinary judiciary, and it, again, changes the dynamic. Existence of competing judicial self-governance bodies. We have had a lot of discussions about judicial councils, selection panels, judicial appointments commissions. Of course, they might be often in tension with chief justices who want to exercise influence on them. Proximity of chief justices to political leaders is another important factor. If you have a former politician as a chief justice, that changes things. I mean, this revolving door phenomenon as well. A legal culture, role of legal profession, that is all very important. So here I will just focus just a little bit on the interactions of chief justices with political actors. As you can see, they can play several roles that might be advising, to ministries, to even, parliamentary committees. Sometimes they might be informally, asked to discuss certain issues. Sometimes they, can be even perceived as a sort of brokers between politicians and the judiciary. I mean, the Merkel dinners, so that I can mention also something from the established democracies are typical, where the president of the German Constitutional Court was having dinners with then Prime Minister Angela Merkel, that raised eyebrows in German circles. And there might be also sort of, negotiations, representations of interests of the judiciary before the parliament in discussing new laws and so forth. There are, of course, risks. All those negotiations inherently harm independence. The Chief Justice might risking politicization of their position as well as their courts, and they might, if they are too critical, they might step on politician toes, and it backfires because then there is a significant backlash from political actors. There is also a second side, which is interactions of Chief Justices with their own judges. So we can see two archetypes. They are sort of two sides of the continuum. So in some countries, I mean, Chief Justices are primus inter pares and then view themselves as such. On the other hand, I mean, Chief Justices might be viewed as bosses of their court when they have a significant impact on how the courts operate. I discussed the interaction of Chief Justices with other judicial self-governance bodies. You can see that these might be, sort of, competing institutions. And sometimes, Chief Justices might try to block the reform, make sure they sit on a new judicial self-governance body, like a judicial council or something like that. They might also want to influence, at least indirectly, the composition if they cannot sit there, or rely on their informal powers and information asymmetry. So there are different strategies. And then I just wanted to show there is a relatively huge variety regarding the selection methods of Chief Justices. So in some countries, it's by the executive. In other countries, it's by the legislature. In Slovakia, for instance, it's by a judicial council. In certain countries, judges themselves select the president of the apex court. Sometimes it's a mixed method where you have, two bodies involved. Sometimes it's by seniority. Quite often it's fragile because it's a constitutional convention. You can see how it unfolds, for instance, in Israel, where this has been considered by many as a constitutional convention. Esther Hayu resigned a month ago, so we'll see who's gonna take the role after her. And of course, you can think of a choice by lot. But as I mentioned in the introduction, it also happens that Chief Justices are dismissed. And you can see that, again, the rules vary. In some countries, it's via impeachment. In other countries, might be via disciplinary proceedings. But we could also see some, discretionary dismissals by the appointing body and some abusive dismissals, often disguised as judicial reforms. That was the case in Poland and Hungary, where the maximum retirement age was reduced in Poland, which accidentally affected also the Chief Justice Małgorzata Gersdorf, or in Hungary, where the Supreme Court was renamed to Curia and the competencies slightly changed, and that was used as a pretext to set new rules and get rid of the sitting Chief Justice of the Supreme Court, András Baka. But the thing is that each solution has its pros and cons, and to a great extent shapes the role of Chief Justices. And of course, there are some, let's say, unique models, such as in Brazil, where you have a rotating Chief Justice, very short term. It's quite clear who's going to become the next Chief Justice, and so forth. So we can discuss those. And I think, given the recent developments in many countries of the world, it's also important to analyze what Chief Justices can do if they are under pressure by populist leaders, newly elected autocratic leaders, or by other external actors such as oligarchs and clans in other countries. So what are the determinants of their success? Do they differ regarding the nature of the regime, if it's an established democracy, if it's a semi-democratic regime, or if it's authoritarian setting? How chief justices can shape their courts and the judiciaries to serve their citizens. So that would be it as an introduction, and I'm looking forward to your comments, questions, and criticism. Thank you so much.
Thank you, David. This is really very helpful to recap what are the powers the chief justices might have. And we see that these are various, very broad powers, could be very broad, their powers. And influences, as you mentioned, as an informal powers of the chief justices, or even might be in different countries, other court presidents, right? These informal powers are also very important to understand and to know how it works. Georgia could be maybe the best, one of the best examples of how little powers, formal powers, can chief or other court presidents have, but again remain the very significant informal powers at their disposal. We will continue discussing these topics later on after the introductions. I will turn now to Caroline. I think it's interesting how OSCE came to little bit changed recommendation regarding the court presidents, and if you talk about that and whatever you think is relevant to mention from that process and the recommendation, please.
Thank you very much, and thank you for having me here today. I'm going to try to share the presentation now, and I hope it will work. Okay.
Yes, we can see it.
Okay, you can see it properly, and you can hear me as well, yeah? Okay. First of all, I'd like to thank you very much for having me here today. It's a real pleasure to be here because I noticed in this group today a lot of names and faces who actually participated in the process of development of the Warsaw recommendations, which I'm going to talk about. And I'll talk a little bit about that process of development, but just to say that experts from Georgia and the experts who you have inside this network, also David, were really important contributors to the thematic workshops that we had on a number of the subtopics. So although the role of chief justices, court chairpersons, court presidents is not one that has a separate section in the Warsaw recommendations, what I've done inside the presentation today is to pick out sort of how the process has addressed that topic and give some compare and contrast with what was in the Kyiv recommendations earlier. So first, I would just say a few words about OSCE ODIHR's work in the area of judicial independence more generally. I will talk a little bit about the process of review of the Kyiv recommendations because this was a very consultative and expert-driven, broad-ranging process, which I think networks like the one that you have organized here have a real potential to contribute to in the future, and definitely did contribute in this case. I'll look at the role of chief justices in Kyiv recommendations, but you're probably already quite familiar with that. I will focus mainly on how the role of chief justices is reflected inside the Warsaw recommendations, which, as Eka mentioned, were published just in October 2023. So this is actually one of the first events where we are sharing them outside of the launch. And then I will point to a few next steps and opportunities, knowing that you are all here are coming from a network which is very active in discussing and working on these issues. And of course, I'll be very happy to hear feedback, comments, questions, criticism during the discussion, because I think I'll talk about it later, but one of the important things about the Warsaw recommendations is that we develop them in order to be a tool and to be a starting point for further discussion of these issues. So when we look at OSCE commitments related to the rule of law and judicial independence, I think I won't go so far into it because that's not the topic to discuss here today. But the important thing to note is that these OSCE commitments are political commitments. So these are not normative binding instruments of international law, which are treaty-based, but rather are political commitments. And these are ones which participating states have voluntarily and freely entered into as political commitments. So our leverage and our space to talk about these issues is perhaps a bit different than in academic circles, than in a normative system where we have a binding force of those judgments. Warsaw recommendations are just one example of ODIHR's tools and methodologies, which we use to support participating states in upholding these commitments. Often we are convening roundtables or expert discussions, which can serve as platform for exchange of views, for dialogue. We are also conducting monitoring of processes of judicial administration. So essentially, we have a lot of different tools that we can use as access points to talk about both good practices and issues where there are challenges. So why did we come back into this area? Why did we touch the key recommendations? Why did we decide to develop something new? What we could see was that from 2010 onward, there were new dynamics which the key recommendations didn't really capture and which were increasingly seen as problematic in a number of participating states. One of these in particular was with regard to the role of judicial councils and to the need to have some recommendations regarding not only the independence of judicial councils, but also accountability of judicial councils. We also saw the need to capture some recommendations related to informal practices or practices that may not be found in law in all participating states. For example, with regard to transfer of judges. And when I talk about role of court chairpersons, I will talk about this with regard to transfer of judges. We also saw really an explosion of normative standards and jurisprudence during the time which we conducted our review. So this was from 2019 until 2023. And of course, anyone who's watching, for example, European Court of Human Rights from this time knows when we started the process, we didn't even have Astrazon judgment or this Astrazon test, and the evolution of jurisprudence related to judicial independence specifically really called for a set of recommendations which would reflect this newly developed jurisprudence. As I mentioned, we had experts from across the entire OSCE region who were participating in discussions, who were reviewing thematic materials prepared by our experts. And when we decided to do this review, we looked both at standards, but also at good practices. So what was actually happening inside the participating states who were sharing these pieces of information with us. And among the success criteria, I've already mentioned it, we wanted Warsaw recommendations really to be a practical tool and not just something that will sit on paper. So this is not a standard setting document, this is not an academic treatise, but this is meant to be a practical tool which will articulate and help participating states understand what compliance with standards and good practices looks like in practice. So turning to the key recommendations from 2010, many of you may be familiar with them because, of course, the geographic scope of those recommendations included South Caucasus, and the experience in South Caucasus, including Georgia, very much informed the key recommendations already. So inside there, paragraphs 11 through 15 are the ones which really address the role of chief justices and focus on the limited role which chief justices should have, the fact that their competence shouldn't be used to interfere with the independence and impartiality of judges, And then we also see topics like role of Chief Justices in case assignment, what kind of say Chief Justices should have in individual bonuses and privileges, what should be the role of judicial discipline of Chief Justices, what should be the term of office of Chief Justices, and then looking at a topic we've already heard from Eka and from David about, what the process of selection of Chief Justices should look like, and the need for transparency and independence inside that process. So inside the Warsaw recommendations, as I've already alluded to in a few cases, we have 5 main sections. The first one of these is about judicial councils and judicial self-governing bodies. We really saw a need to reflect what standards related to accountability of these bodies could and would look like. And so this is why the first 2 sections of the Warsaw recommendations, and I should probably share the link to those inside the chat. Maybe I can do it right now. What those look like. This is very much, you can also Google it online, but I share it in the chat now. So those are the first 2 sections. The third section is one where we looked at disciplinary bodies and proceedings. We found that international standards in some cases did not really provide enough practical guidance for what kinds of safeguards needed to apply inside those proceedings. And in parallel, we saw very problematic practices in a number of participating states related to formal use of disciplinary proceedings, but also to de facto forms of judicial discipline. During this time period, we've also seen the European Court of Human Rights frequently speak on what those standards should look like. We looked at freedom of expression and freedom of association of judges. And this is something that, while that section does not specifically discuss the role of court presidents or court chairpersons, I think there are some interesting questions, which perhaps it leaves open there. And even during the presentation of David, I was reflecting on some of these, given the recent jurisprudence of European Court of Human Rights and the duty in certain cases of judges to speak out on matters related to the rule of law. Then we looked at judicial tenure and the transfer of judges within and between courts. This was a huge area for us where we saw across the OSCE region very problematic practices. And we saw that transfer of judges was often used to disguise other forms of de facto disciplinary sanction or as a type of punitive measure. And we saw a need to articulate what kind of safeguards needed to be in place. And then in the last one, we looked at equality, diversity, and non-discrimination. The topic of gender diversity and justice is one that we as ODIHR have worked on in the past. And here we tried to take it a step further and to look more broadly at how the composition of the judiciary itself and the behavior of the judiciary itself with regard to principles of equality, diversity, and non-discrimination should look, and how this topic is connected to public trust and confidence in the judiciary as a whole. So moving to the next slide. Regarding judicial councils and self-governing bodies, what I've done on these few slides here in the minutes I have left is I've picked out parts from the Warsaw recommendations, which specifically relate to the role of court chairpersons. So really the underlying recommendation in this section is that judicial councils and self-governing bodies, where they exist, should themselves be independent and impartial. We know that the key role of these bodies is to protect and to preserve the independence of the judiciary, but we also saw it and found it important to articulate that these bodies themselves need to be independent and impartial. We again make the recommendation that the judicial councils should not be dominated by judges from higher instances. And we fairly consistently were told that if a court chairperson is elected as a member of the council, that court chairperson should resign from their role as a chair. This is to avoid the undue concentration of power and overlapping powers inside the council. We looked inside the Warsaw recommendations at the process of election of judge members of judicial councils. The recommendation inside the Warsaw recommendations is that judicial councils should be composed of a small majority of judge members. And among those judge members, we recommend that the peer election of the judge members must be free from executive and legislative interference. But here, I think it's relevant as we're talking about court chairpersons or presidents of courts, that this peer election of judge members also needs to be free from interference from judicial authorities who are external to the council. So we found that it's not only enough not to have court chairpersons being part of the council, but that the process of election of judge members by their peers to the council should be free from this interference by other judicial authorities. With regard to disciplinary bodies and proceedings, I think you will see in the Warsaw recommendations something which is quite similar to what's in the key recommendations, but perhaps a bit more elaborated. So again, we say that court chairpersons should not have the competence either to initiate disciplinary proceedings or to adopt a disciplinary measure. And this is what is inside key recommendations. However, court chairpersons may file a complaint to a body that's competent to receive complaints and conduct disciplinary investigations. So the recommendation does not mean that a court chairperson would not have the power to file a complaint in the case of being aware of a disciplinary violation, which has allegedly been committed by a subordinate, but to have the court chairperson be empowered to directly initiate the proceeding or to adopt the disciplinary measure would constitute excessive interference with the independence of the judge. Regarding freedom of expression and freedom of association of judges, we do not specifically address these freedoms insofar as they relate to chief justices, court chairpersons, or court presidents. But I think inferring from the judgment of the European Court of Human Rights in the Jurek case, where the court found that a duty to speak where the rule of law is called into question or threatened may attach to a judge in particular circumstances. In that case, it was a spokesperson of the Judicial Council. We may find that court presidents may in particular have this duty to speak out in defense of the rule of law in certain circumstances. We could also discuss it. This is just what I'm positing here. With regard to judicial transfer and the tenure and the transfer of judges within or between courts, here we had a lot of, I would say, very rich, heated, and diverse discussion in the workshops that we had. We found that court presidents should have the flexibility, and they needed to have the flexibility to transfer judges internally. But these transfers must be done lawfully, fairly, and transparently. And most importantly, and I think the most important part of the section of the Warsaw recommendations related to transfer of judges is that these transfers need to be done with adequate safeguards. And one of these is a written consent of the judge who's being transferred. So 35 and 36 in Warsaw recommendations are particularly on point with regard to that. And then as far as equality, diversity, and non-discrimination, you will have seen it in ODIHR's previous recommendations as well. But here we again recommended and called on executive, legislative, and judicial authorities to adopt measures that would ensure gender parity in judicial self-governing bodies and also in senior positions in the judiciary. So we know that when it comes to senior positions in the judiciary, this is often one where gender parity is less frequently found, and that judiciaries and executive and legislative organs should also consider adopting specific measures to ensure adequate representation of minorities in these key positions. As far as next steps and opportunities, I mentioned some of these already. These talking about what are the OSCE recommendations good for and what could we use them for. We would like to discuss these recommendations with different types of stakeholders, discussions like the ones that we are having today, but also discussions with judges, with legislators, with state authorities, with academia, with associations of judges. I think the recommendations are a good tool for opening up questions and discussing some perhaps problematic issues where we could understand where more support and capacity building might be needed. And I've already mentioned this monitoring of processes related to judicial administration. I will just say again here that ODIHR stands ready to receive requests for monitoring of these processes related to judicial administration. And in the Georgian context, this is one where, upon request of the Office of the Public Defender in the past, we did do monitoring of process of nomination and appointment of Supreme Court judges. So we're definitely willing to do this type of monitoring again in the future, and we have a special methodology for doing that. And I think that this tool, the OSCE recommendations, will assist in providing standards and guidance that would be used and applied when assessing the findings of that kind of monitoring. So with that, I think I've used my time. I would look forward to further questions during the later session. And thank you very much again for having me here today.
Thank you, Carolyn, very much. For me, key recommendations and also now OSCE recommendations are very interesting, always have been, because they are specifics that they usually OSCE considers the peculiarities of different legal systems, and you don't encounter it in many European recommendations. Usually they are very they approach subject not considering particular problems in countries which are always different. I will not abuse my power to ask questions. I will postpone for later on. Thank you again, and I ask now Nazi to talk about Georgian context. I already introduced Nazi. I think she joined us little bit later. So Nazi, the floor is yours, and we are listening to the Georgian context. Thank you.
Thank you so much, Eka, for this introduction and also for the invitation on this conference. So it is really important for me to share our perspectives, what we think about the institution of the chairman positions in Georgia of the courts. So I represent the organization Georgian Court Watch. As Eka mentioned, I was a member of the High Council of Justice of Georgia in 2017 and 2021. And it was our obligation as members of the High Council of Justice to appoint the presidents of the courts in Georgia, except the Supreme Court of Georgia. I mean, first instances of the courts and appeal courts. So first of all, on screen, we have a here article, what was prepared by our organization. I will share here some of the articles, which is about the chairman, and I will share with you in the network as well by email. Before we start talking about the regulations or I don't know policy in Georgia about the Judicial Council and the chairman, it is important to mention from my perspective as a former member of the High Council of Justice that it is a network of the people in Georgia who are the power and have the possibility to influence, not about only cases. I don't mean only cases. It was an ordinary practice in past in Georgia when the chairman had very, very important tool to distribute the cases amongst the judges. But currently, one of the important issues, it is a network. So I remember when I was a member of the High Council, there were some of the issues the Judicial Council judge members wanted to distribute. And I remember they mentioned that they have a WhatsApp, kind of a group, and they are sharing information, and everyone is following. I mean, every presidents of the courts in Georgia are following these rules, and I don't know tasks what they are assigned. So the problem is that, as you know, that European Commission in Georgia recently, for Georgia recently, made the recommendation and about the reform of the judiciary, and one of the issues is to check integrity of the high officials in the judiciary of Georgia. Especially there was talking about the members of the High Council of Justice and presidents of the courts. So as you know, in Georgia, we have a very special situation. I know we had the discussions about it quite often, that there is a clan-based governance, but who is a clan in Georgia? So first of all, the people who are involved in these clans, they are chairmen of the courts and members of the High Council of Justice. So if you want to identify these people, of course, we should see their positions. So the problem is maybe in different aspects, but here I will show, I'm showing the article where it's mentioned the details, how they are appointed, the term of the authority of the presidents of the courts, it is 5 years. So it is a quite long, I think so. And we have a situations in Georgia when the presidents of courts are appointed more than 10 years because their term was renewed several times. And we have examples when some of the presidents are appointed for less time, like 3 years or 2 years, even in small or big courts. So it doesn't matter what kind of courts it is. For instance, Tbilisi City Court in Georgia, it is biggest court because it is there is more than 100 judges, and sometimes they change very frequently the presidents of the courts, but there is no justification in the explanation of the High Council of Justice decisions why the president of the court, for instance, in Tbilisi City Court, was changed several times. So as I mentioned, that the High Council of Justice is obliged to appoint the chairman of the courts in Georgia, but the legislation about this process of the selection of the presidents was changed. And there is obligation currently that the Judicial Council members should have the consultations with the judges in the same court where this particular person should be appointed. So issue is it what does this consultation means? And another question arises when this consultation process is going. And I remember one of the example about the Tbilisi Court of Appeal chairperson. There was a consultation. It happened around 1 year ago with the judges, and there was an unprecedented situation because more than 50 judges attended the consultation because the process of appointing of the person was important because of this particular person, because this person is one of the influential judges in Georgia. But in other courts, for instance, when the judge is appointing for the position of the president, there is not so big activities from the judges. Maybe sometimes 5 or 6 judges are attending this consultation, and this is very, very formal process. Everyone is mentioning that this person has very good experience, will be important contribution for the particular court. It is really formal process and doesn't have any meaning on the decision. So I want to share here that the one of the issue about the independence of the courts. What's the possibilities chairpersons in Georgia have to influence the judges? So in Georgia, we had the situation where the cases were distributed by the presidents of the courts, but currently we have the random distribution of the cases by the electronic system. But there is some exceptions when the system is damaged. For instance, there is some kind of electronic problems or either systemic problems. The president of the court can distribute the case among the judges. So they still have very, very important possibility, and nobody can be informed and aware about what kind of systemic damage was there, and it was true, if there was some real reasons or not. It is quite important issue and problem here in Georgia. Another issue is that about the interference. It is not an issue of the legislation always. It is an issue of the perception of the judges. There maybe sometimes I have when I have the possibility to talk with the judges in Georgia, they are sometimes see the president of the courts as their boss, as their leaders. Maybe somehow they are leaders, but not the boss. It is a big difference. So the problem is that another problem is that the system in Georgia, judicial system, is very centralized. Every issues, even if, for instance, organizational issues, like if the court wants to buy the paper for their, I don't know, daily work, they need to ask judicial council about this issue, about this kind of organizational matters. So it means that everything goes to the judicial council, but still presidents of the courts have kind of different kind of influences. Another issue what I wanted to share here, it is a I will try to switch another slide, but yeah, I cannot, unfortunately. Another issue, it's obligations. I hope you can see it, but I will, maybe no. Yes, yeah. Another issue is that management responsibilities of the presidents of the courts. In Georgia, we have the system that every court, every big court at least, they have the managers, and according to the legislation, unfortunately, the presidents of the courts still have very important managerial functions, and therefore they are explaining reasons why they are not discussing about the cases. They are not so busy as the judges because of the managerial responsibilities. We consider, our organization considers that there should be reform about it, because management body, managers in the judicial system in the courts should have more responsibilities as the managers. But as regards to the presidents of the courts, they should be more like representatives of the particular courts, and we think it should be kind of solution. Another issue what I wanted to mention is that there is differences. We created judicial effectiveness index. We evaluated the court system, every court in different matters like infrastructure, for instance, organizational matters, decisions and policies inside the particular courts. And what was a little bit surprise for me, that there is some kind of there is some kind of differences between the courts. Even if we have a clan-based governance, we have a centralized system, there is differences. And we have one of the court, for instance, to have to mention as like one of the best practice. We have one of the court, for instance, Varšavis City Court, when the president of the court inside this particular court have different decisions, like about the infrastructure, for instance, services, what they are providing for the citizens. I don't know, they have a different attitude even to publicize different decisions and public information for the citizens, which is very important for instance, researchers. So the issue is that even in this situation, when the process is very centralized and the president of the court has are like people who are network members of the judicial clan, they still have some kind of possibilities to have more progressive decisions in the particular court as an organization, as a particular system. But one of the important issue, what I would like now finalize my talking about the judicial presidency, the judiciary, is that in Georgia, Supreme Court Chief Justice, Supreme Court President, is an ex officio member of the High Council of Justice. According to the legislation which was changed in Georgia some years ago, there should be a new president, new chairperson is the High Council of Justice, should be who could be elected by the High Council members, High Council of Justice members. But unfortunately, High Council of Justice, because it was not deprived, decided to elect the same person as a head of the High Council of Justice. And currently we have the situation when the one person still is on the two positions, as a Supreme Court chairperson and as a High Council of Justice chairperson. So the issue is that we don't have the possibility in Georgia when this to open this process and to give the opportunities other members, even if they are judges or I don't know, even members of the clan, but they are not giving the possibilities everyone. So another issue, and I will finalize here, is that when we see the statistics, and I will share this information with you, when we see the statistics who are appointing as the presidents of the courts, who are not reappointing in another court, for instance, we see that this group of the people, there's a group of the people of the presidents who are very mobile, let's say so, and they're changing the just courts, but they are all vice presidents in different courts in this part of Georgia or west part of Georgia, and it means that they're like persons who are trusted by the influential group of judges in Georgia. And unfortunately, other people are not willing to become the presidents of the courts. And that when I was a member of the High Council, I asked several times different judges, for instance, women judges, you know, if they are wanting to occupy such important positions and contribute to the development of the system. But they said that you're not, they are very busy. They are not willing to be like a managers of the courts. They are not willing to have new responsibilities, etc. So the system what we created and what was created in Georgia is not open, and it is just recognizing the same people, and it is just supporting, promoting the same people on these positions. And unfortunately, from inside system, they are not big, not application. So many people also can apply to the High Council of Justice to be appointed on the position, but on the vacancies, when there is any vacancy, there is one or two applicants. Unfortunately, they are not just willing. Maybe because the reason is that they are not, they did not have any pre-negotiations, or I don't know, hope they will be supported by the High Council of Justice. But the problem is that They are not even expressing they are willing to be appointed on this position. So this system is very, very closed in Georgia. We have some amendments in the legislation, but it didn't affect. And we have, for instance, obligation in Georgia to justify the decision when the president of the court is appointed on the position, but we see that justification is very formal. Just there is changing the names, I don't know, dates, formal issues, and the justification why this person is important to be appointed on the position, how they can contribute, or I don't know, any other aspects. There is no justification about these important aspects. Thank you so much.
Thank you very much, Nazi. It's very interesting to understand that on Georgian example, you see, and what I see in Nazi's presentation is that even if you sometimes have good laws in place, or you change the laws in order to bring some restrictions with the aim to improve this concentrated powers situation, you still don't have proactivity among other judges. This perception, Nazi mentioned, is there, but also court presidents remain their powers in the High Council of Justice. That is something also to be, I guess, to be talked about, whether it is so important to preserve court presidents in the High Council of Justice, at least as a transitional measure, maybe. Okay, I will stop here and give the audience the opportunity to engage in the discussion. Let me share some rules. You can ask questions or write your questions in the comment section, and I will voice it for you. We already have one question awaiting in the comment section. I will raise that first, and then Kacha is raising hand, I see, and whoever else wants, please do. Well, this is our former Georgian judge asking the question about to David. Question is addressed to David, whether in Czechia you have clan, something like the small group of judges with big influences, and what are the measures taken against if there is this problem, or if you are aware about the situation in other jurisdictions, you can comment on that as well. Clan, and what are the measures the states are taking against it? That was one question. And also, if you mentioned, David, in your presentation that there was a ethics code for Supreme Court, and the question is whether there are separate ethics codes for different courts, for different instance courts. That are two small questions. Okay, David, you can answer, and then we proceed with the questions.
Okay, I'll start with the second question. Can you hear me well?
Yes.
I think when I was referring to the ethics code, I was referring to the recent code of conduct adopted by the US Supreme Court. And in the United States, there was a code of conduct for lower federal judges. But until very recently, there was nothing like that for the Supreme Court of the United States. And it was adopted only very recently. So yes, at least in the United States, it is possible that there are separate ethical codes or codes of conduct for the apex courts on the one hand, and codes of conduct for lower courts. Of course, the Supreme Court of the United States is a very special institution. I mean, Jim might comment on that. And until very recently, it tried to be as little constrained as possible. But there was I would say growing criticism that they are outside of the scope of the recent code of conduct. So they adopted one which is similar but not the same. And of course, it responded to criticism of some, trips by Supreme Court justices allegedly paid by some donors of the Republican Party and so forth. So that's one thing. I'm not saying whether it's good or bad, but I'm just saying that it's possible. Then regarding the second question, the clans in Czechia, I don't think we have the clans in a way you know them in Georgia. I read several pieces by Nino Tsereteli and others writing about this judicial oligarchy. So I think it's not the case in Czechia. I think that the individual judicial independence is a bit stronger. So judges are basically dispersed into several groups. Of course, some groups, talk to each other, some groups do not. But I think there is a growing, competition, and you can't see just one clan that would, just, capture the positions of court presidents, not even 2 or 3 clans. So it doesn't work like that. It might be also because of the fact that we don't have a judicial council in the Czech Republic. So there is not this unified judicial self-governance structure. So there are open calls for each vacancy at the position of a court president. People can apply. Right now it's rather transparent, and there is a mixed commission. So there is an increasing number of candidates, which also helps, because in the past there was usually one candidate kind of chosen by the incumbent court president. Right now it's different. They have to provide present competing programs, what they want to do with the court and so forth. And I think that this transparent selection also help female judges to get to some of the more important positions at the presidency of regional courts. So just 3 years ago, we had no female regional court president. Right now, we are having 4 or 5 out of 8. So the introduction of this procedure might be also an answer, transparent selection procedure and enticement to apply, that if you want to change something in your court, you have to apply, made the difference. Of course, it's only up to the regional court level. At the Supreme Courts, we still have, pure males in terms of chief justices and court presidents. So I will stop here.
Thank you, David. Jim, if you would like to reflect on the question, I will give the floor to you. Otherwise, it's Kacha's turn.
Yeah, it will just be very, very brief. Yes. I just wanted to point out, and it's not very important to our topic today, so I don't want to carry on about it, but I don't want anyone to give too much credit to our U.S. Supreme Court. Yes, they have adopted a code of conduct at long last, but they adopted a very poor code of conduct that uses the word may rather than shall almost throughout. And furthermore, most importantly, they did not submit to any sort of enforcement mechanism for this new code of conduct. So there is no way to enforce the code of conduct that the U.S. Supreme Court just adopted. It is still largely, almost entirely, up to individual members of the court to decide whether they need to recuse themselves or not, and to apply those rules to themselves as they see fit. But there is no enforcement mechanism. So I don't want anyone to give too much credit to our very, very disappointing U.S. Supreme Court in terms of holding itself to ethical standards. But thanks very much for the conversation. I've enjoyed it very much. I'll look forward to the rest of the discussion.
Thank you for this very specific intervention. I will just clarify that we have officially 15 minutes left, and please use this time as efficiently as possible. And Kacha, the floor is yours.
Thank you very much to the dear speakers. The presentations were very interesting. So my name is I'm Kacha Zikarishvili. I'm a member of the group of independent lawyers, and I would like to continue from the previous question about the clans that the former judge has asked the question about the clans in Europe, and I would like to elaborate further on this question and specify the Georgian experience. And I would like to ask the dear speakers, particularly David, whether this kind of similarities may exist in other countries. I think David was one of the pioneers back 10 years ago, and I read his articles about judicial mafias. And I think 10 years ago, David was predicting what would happen in Georgia. I think 10 years ago, nobody has read David's article about judicial mafia. And exactly what happened in Georgia was exactly what David Kosar has predicted 10 years ago. That, the countries in Eastern Europe, judicial mafias may grow up, particularly in self-government, in the context of the self-government. And unfortunately, we did not have access to these articles 10 years ago, but I was feeling that something was happening, something like that was happening. I just had feelings, and I was actually expressing myself publicly, and I have made a public demand to have a thorough examination of the judiciary and the assessment of the past experience of Georgian judiciary in order to assess what happened in Georgia under previous government. What was bad? How was the judiciary governed? Who was in charge? What was the problem of independence of judges? Unfortunately, the Georgian Dream did not share my proposal, and they did not make any thorough assessment of the previous judiciary. So, and unfortunately, the Venice Commission was very naive. I'm not gonna restrain myself in saying it this way. I think the Venice Commission was very naive in recommending judicial self-government here in Georgia, and without comprehensive assessment of the background of Georgian judiciary. So what are my questions? My question number one is whether in Europe, in any country with this kind of judicial mafia, whether in any other country in Europe, the mandate of all judges have expired, like in Georgia. In Georgia, in the last 10 years, judges were appointed for a 10-year period, and everybody's term of office expired. So they were vulnerable towards the judicial mafia. So they just didn't have a choice. They had to either support the judicial mafia or resist the judicial mafia and stay out of judiciary. So they had some kind of screening or filtering inside the judiciary. So this governing mafia, they screened the entire judiciary. They screened the entire judiciary to retain their supporters and to dismiss their opponents. Now, question number two is whether you have political. In other countries of Europe, you have secret bargaining between judicial mafia and political power, like governing power. Because these two things are very dangerous. If you have a judicial mafia who is in charge, and if you have a secret bargaining with the political power, then these tools are very dangerous because you may have a monopoly over judiciary. You may have a complete monopoly over judiciary if you have a political support and if you have a power to reappoint all the judges. So this is my question, because I think that Georgia does have very big problem with considering these experiences, like that everybody's mandate was expired in the last 10 years, and there was a secret negotiation between judicial mafia and the current government. And my third question is, what happened to the chief justices when there was a change of power. This is particularly to David, who has studied the experience of the Chief Justices. What happened to those Chief Justices when there was a change of power, you know, in other countries? Those Chief Justices, they opposed the new government, or they collaborated with the new government, or they were in confrontation with the new government. You know, what happened to those Chief Justices? That's also a good question. Well, actually, I think I'm going to stop here and just hear the rest of the.
Thank you, David. Please, the questions were to David, right?
Yeah, primarily to David. Yes.
And yes, and then there is a question for Caroline. What is the position of the Warsaw recommendations regarding the majority representation of judges in judicial councils? Please, David, and then we turn to Caroline. Thank you.
Caroline, don't you want to go first to switch the responders?
I would be happy to, but I don't want to take away from you. Kaha, thank you for these questions. I mean, regarding the questions which are addressed to David, I would just only say, and I tried to indicate it in my presentation, that I think you have pointed to a dynamic which has been present since 2010, basically that we did not fully appreciate the problems which may exist when judicial councils in and of themselves amass too much power, and this problem of cronyism, of corporatism, of lack of accountability of those councils was really where the pendulum kind of swung from one side to the other. And this is very much why we've tried to include in here reflection also on the Georgian experience when we talk about accountability of councils. So we know that unless there is a culture of rule of law and of separated powers more generally, and unless there is a well-functioning system of checks and balances, any individual measure in and of itself will not be enough. And this is why we've kind of tried to approach it from a culture of accountability and the need for this accountability. I would leave to David to give other reflections on that, but just to say that part. With regard to Warsaw recommendations and number of majority representation of judges in judicial councils, you'll see in recommendation 2 that we do say small majority of judge members. So if you remember, Kyiv recommendations at that time said substantial number of judges, which does not necessarily mean majority. And Warsaw recommendations, we say small majority. And we felt that small majority was needed in order to adequately ensure the independence of this body. And so this is one place where there is a divergence between what was in Kyiv recommendations and now in Warsaw recommendations. I think consensus sits pretty much at small majority, which doesn't mean, I guess small majority can mean 51% or more. It's not, you know, it's up to countries to decide. So I'll leave it there.
Thank you. Thank you, Caroline. David, as briefly as possible.
Yeah, thank you. I mean, thank you, Kaga, for these questions. What happened to those Chief Justices under pressure? That's a long answer. The short one is that with Ross Dixon and Erin Delaney, we are preparing a symposium for ICON, so it should be out at some point. The slightly longer question is that many of those fought back. I mean, Czech Chief Justice Brožová successfully fought back at the Constitutional Court. Małgorzata Gersdorf managed to find support at the Court of Justice. Israeli Chief Justice Esther Hayut, she just finished her term like a month ago, and she was not, you know, removed. She was very vocal. She fought back, but not, I mean, there was no retaliation. In Hungary, it didn't work out. András Baka was removed, and then he fought back at the Strasbourg court, but it was too late. So quite often, you know, Chief Justices fight back, and sometimes they are successful. The problem is that their term is limited. Therefore, I mean, also the resistance is limited in time. Of course, there are also Chief Justices. I know examples from Kenya, Brazil, or recently Chief Justice Zaldívar in Mexico that were sort of, you know, collaborating with the political leaders. but sometimes, I mean, I would say it's even necessary. I mean, in Kenya, I mean, can you imagine that you can fight the strong, political leader with this political and legal culture? You have to navigate very carefully and so forth. So, I mean, I wouldn't judge it, too harshly, because it depends also on the political context. For someone, it's collaboration. For another person might be strategic defection or preventing the worst from happening, and it's tricky to assess from table from here from the nice chair in Berlin right now. So I wouldn't be too harsh. Then the second question, I mean, the Georgian example, I think that limited renewable terms of judges are in themselves very problematic. And well, in a sense, there is no way out. I think that in many countries, the so-called probationary judges, Richter auf Probe, were abolished. In Poland, even in Russia, it was abolished, as far as I know, because it was highly problematic when you could renew the term of a judge, and having it on permanent basis, like every 10 years. That, of course, politicizes the judiciary, no matter who is involved, whether the Judicial Council or politicians or someone else. So I think that the way out of this is to abolish at least the renewability of the term, or at least appoint judges for life. I mean, until they reach the mandatory retirement age, because otherwise I don't think that even a decent established democracy can handle that, perhaps with the exception of Switzerland, but I guess we are not the Switzerland in any of our countries.
Thank you, David. I have one more question to go. Keta, please.
Good afternoon. Thank you. First of all, I want to thank Caroline, David, and Nazi for sharing their experience and for this very interesting and comprehensive and excellent presentations and information. Thank you, David, for your work and for this expertise. And thank you, Caroline, for this new updated information. We were so interested on this. I have one question to Caroline. What do you think if as from your recommendations and updated informations, I want to ask you if the membership of the chairpersons in the councils will be fully prohibited? Can it help to deprive the rights of excessive rights of chairpersons, and it will be like helpful for not be concentrated the power in the High Council of Justice?
Thank you for the question. And again, thank you for having me here today. I mean, what we have recommended is that where the chairperson of a court is appointed to the council, that they should resign from their position as chairperson. That it would be, the power would be too concentrated to have someone on the council who is also a court chairperson. I know in practice, as you've mentioned, there are situations where there are members of the council, court chairpersons who are ex officio members of the council. I see this as potentially being quite problematic in terms of concentration of power.
Thank
you. I'm just checking in the comment section if there are other questions. Okay, no more questions. I think we're quite on time.
Eka, may I just have a very quick question for Caroline, if I may? Caroline, I just wanted to ask you, thank you very much for being here and for sharing the Warsaw recommendations. When I compared the Kyiv recommendations and Warsaw recommendations, I was just wondering, given the topic of this session, why you abandoned in Warsaw recommendation the separate section on chairpersons, because there was far more in the Kyiv recommendation. Is it because of the regional focus, or because of other considerations, or you can see that there is a, let's say, greater divergence? I just would like to know why, if you can share it.
Yeah, of course.
If you can't, of course, you.
No. It's a very good question. I think that for us, part of the reason that court chairpersons were included in Kyiv recommendations was that the situation in the geographic region that Kyiv recommendations covered had more or less a unified or a similar origin for the legislation and for the system. And so the problems and challenges that we had to look at related to court chairpersons looked more similar within those sub-regions than when we decided to expand the geographic scope. So when we decided to expand this geographic scope, the practice related to court chairpersons looked really different. Systemically, it looked really different. The types of problems that participating states had looked really different. And so I should have mentioned at the beginning, but Warsaw recommendations definitely are not an exhaustive assessment of challenges related to judicial independence. Rather, what you do find in there are the things that we thought and we found and we heard from people were the biggest gaps. So these are like, when we did a gap analysis, the biggest gaps were those areas. And so this is why there's not a separate section on court chairpersons.
Okay, thank you. May I also ask one question, since there are no questions in the audience right now, just to seize the opportunity. Since the vetting processes are so, how to say, come to the discussion very often right now, and Venice Commission, for Georgia, for example, I think this is the first time when Venice Commission recommended actually to vet some certain judicial positions. But in other countries, we've seen vettings done and they are ongoing. In Georgia, we have Supreme Court, all Supreme Court judges, of course, including the court president, the Chief Justice, they may be only impeached. And David was mentioning about the impeachment. So Supreme Court judges can be impeached. They cannot be disciplined. And from the vetting perspective, that could be hindering the vetting process somehow. Whoever wants to reflect on that, why is it so important to have impeachment procedure for Chief Justices or other Supreme Court judges, especially if you have a context when Supreme Court judges and Chief Justice particularly does not have that many powers? Maybe, I don't know, maybe David can reflect on that.
I mean, I can respond to that. I think it's a very complex question. First of all, I would like to mention that there is a case by the Strasbourg Court, Gumenyuk versus Ukraine, on impeachment, which can be interpreted in many ways. Some people even interpret it. So some people even interpret it as prohibiting impeachment of judges completely. I don't know. I don't share this view. So that's one thing. The second thing, I mean, any removal of chairpersons, chief justices is complicated, and it also depends whether you remove them also for, let's say, managerial problems, qua chairpersons, qua court presidents, qua chief justice, and you keep them as judges, as regular judges, or whether you want to impeach them or discipline them, or not only as court presidents, chief justices, chairpersons, but also as judges, basically remove them from the judicial office. And these are different things. And I prefer, if there is a constitutional court, I prefer if this procedure takes place before the Constitutional Court. So it's not the same court that basically decides, on the fate of its own chief. But of course, if a Chief Justice of the Constitutional Court is being, impeached, then it's again tricky. I'm not necessarily against, the US style impeachment, but I know it's not having many fans in Europe, to put it diplomatically, and I don't know whether it would withstand the scrutiny before the Court of Justice or before the European Court of Human Rights. But it's a complex question that is not easy to answer. And as I put in the chat, there should be, by Paul van Zyl and Christine Murphy, there should be a monograph on vetting of judges in Routledge coming out soon. So there are quite a few answers. I would say not all answers, but some answers.
I'm sorry, David, I just brought your article here in the chat where you are talking about judicial mafia. You're talking that judicial councils are turning into mafia-like structures of judges seeking personal gain and using new institutional structure to power oppression. This is the article David Kosar and Michael Bobek, 2013.
Yeah, you are right, but I would say, mafia-like structures. It's not necessarily judicial mafia, but you are correct that in this one piece, we are saying that it might happen.
So this is what happened in Georgia. This is what happened in Georgia. What you have predicted 10 years ago, this is what happened in Georgia.
Okay, thank you very much, David. The monograph you mentioned, is it already out, or I think you said
not yet. I will keep you posted. I will send the link, to the group once it's out. It's been in production for ages, but it's not yet out.
Yes, thank you. Carolyn, if you would like to reflect, otherwise we are, I think, wrapping up.
I would just say very briefly, because we started on this topic of vetting, and this is not the topic of the discussion today, but I think this question also for me and also for ODIHR, the question of what to do when there really are systemic challenges related to judicial independence and the functioning of the judiciary, rather than being able to use regular measures, is one that we are also looking at. And we had a discussion about, did we include recommendations related to vetting in Warsaw recommendations? We decided not to do so, but I think this is the next area of work for us also. That's all.
Thank you very much. So there are, I don't see more questions in the audience. So I thank everyone for today's very interesting discussion. This is a really very complex topic, of course, and we should continue discussing all these issues. But it's very promising that approaches and recommendations evolve, and they consider specific contexts and situations on the ground. So thank you very much, everyone. It was a pleasure to have you, and follow our next discussions.